Good morning. The second OA of the morning is Long versus Cruz, case number 2024-3450. Counsel for the appellant, would you like to reserve any time for rebuttal?
Good morning. Yes, Your Honor. 5 minutes for rebuttal. Thank you very much.
So noted. When you're ready.
Thank you. May it please the court, Andrew Harris on behalf of the appellant plaintiff here. This appeal on summary judgment, of course, de novo review presents a straightforward question. When an offer conditions, as the written offer here, a tender of two payments, bodily injury funds and diminished value check, when an offer requires a tender to a particular location, which it did here, the plaintiff's counsel's office, within a set amount of time, 30 days. If those conditions do not happen by that date, do you have a settlement? The trial court answered that question, yes. On rehearing, the trial court did indicate another court may disagree. We respectfully ask this court to reverse the trial court's finding of a settlement agreement.
What do you do with our case, ABC Liquors 2007 Fifth DCA case? I'll just read you a quote. What constitutes an essential term of a contract will vary widely according to the nature and complexity of each transaction and must be evaluated on a case-specific basis. Is that a fair statement of the law?
I do believe it's a fair statement of the law. There's, in certain situations, if the plaintiff's counsel had said that a check needed to be delivered that was blue and a check that was delivered which was aqua, is that an essential term of the contract that a check had been delivered in blue? I could make the case for it, but I could understand a court saying that the color of the check is not essential. But here the terms were essential. The tender had to be delivered, had to be to plaintiff's counsel's office within 30 days. The letter states
Counsel, does it actually say delivered anywhere in that letter?
No, you're absolutely correct on that. That's a colloquial misuse of the word. The letter says
It would have been really good if it had said delivered for you, wouldn't it?
Yes, except
I'm not saying you're going to give up on the other, but I mean, if it said delivered and they didn't deliver it,
the letter could have said, yes, Your Honor, could have said it had to be physically placed in the office by day 30. It would be a clearer case. But it does say tenders to our office. And so that is no different in reality. It was the funds were not delivered to the office. And what's important here, there is a suggestion in the answer brief that plaintiff's counsel did something wrong. There is no evidence, the trial court did not find. If there's an obstruction of tendering, of delivery, of production, that could be a different case. We saw that in the Lee case where the office was closed during a time when the offer was allowed to be made. We saw that in the Cullum case, another instance. There was an attempt to produce, an attempt to tender and deliver the funds. The office was not open at a time when it was supposed to be open. You have nothing here. Now, the defendant is correct that you look at the letter, there's 3 addresses on the letter, right? There's a Scrivener's error, which says tender to our office at Suite 200, the top of the letter, Suite 300, and there's a P.O. box. But none of that matters because all of those 3 were valid addresses and neither of the checks went to either of those addresses. In fact, the diminished value check, now yes, it's a smaller amount of money, but it's still a material term which said a check payable to, and it named the plaintiff. And the next sentence—
Is that a relevant part of the letter? That sentence, this check shall be made payable to the plaintiff, is that relevant? The reason I ask is when you quote the letter in your brief, you say the relevant part is this, and you leave that sentence out. Why?
Well, that was inadvertent in the initial brief, and I think opposing counsel, to her grace for me, acknowledge in the answer brief that that the initial brief later on goes to discuss that exact sentence. And so that was just an inadvertent copying from copying from the record on appeal over that, with a copy and paste. So that sentence certainly was not intended to not be in the initial brief. I do, of course, apologize for that. But the diminished value check shall be payable to Matthew Long. We will ensure that the funds are properly distributed. What the defendant did is, instead of tendering the check, the diminished value check, to the plaintiff's counsel's office, decided themselves to send the check to the plaintiff individually to his home address. As it is, they got the address wrong, and so the check ended up being sent back. But they took it upon themselves, as the recipient of a unilateral offer, to decide to send it to an address which is nowhere mentioned in the letter. And that sentence, "We will ensure that the funds are properly distributed," the fair and reasonable interpretation of that letter is that both of those checks are supposed to go to our office, which is the reference above. And so that is a decision, the trial court referred to where there was a good faith attempt here. No one's suggesting that the GEICO representative was in bad faith in sending the check to plaintiff's personal address, but they didn't complete the terms of acceptance of the contract. And I'm not aware of anything in the case law which says a good faith or bona fide attempt where you have a unilateral contract which requires acceptance and performance by a date certain. If you don't perform, you don't perform. There's not a meeting of the minds. And those are essential terms. And the trial court said, well, plaintiff's counsel was just a conduit for the diminished value check. And so what difference does it make whether it went to the plaintiff's address or attempted to go to the plaintiff's address?
Let me go back to the ABC Liquors case again, one of our decisions. Another sentence. A subsequent difference as to the construction of the contract does not affect the validity of the contract or indicate that the minds of the parties did not meet with respect thereto. Again, is that a fair statement of the law?
I believe so, yes.
So could that not be the situation here, that the GEICO's view of this and your view of this may have differed, but there could still be a meeting of the minds?
Well,
as to what you were just describing,
as to the location
payment, correct.
Well, ultimately, it doesn't matter because the check didn't arrive. This would be a harder case if the check had arrived at the plaintiff's house or apartment. It didn't arrive there.
Well, it was postmarked.
It was postmarked, and it was sent. The bodily injury check, there's no proof that it actually was sent. I know there's business records, testimony, but in terms of the diminished value check, it was postmarked, it was sent. But I'm not aware of a case where performance, you must tender to our office by day 30. It was not.
Well, the cases are legion, though, about tendering, dropping it in the mail. I mean, you would agree, there are dozens and dozens of those cases, saying that that's a valid tender, correct?
There are cases, if it didn't say tender to our office, that could be a different story here. But the phrase tendering to our office by a date certain, there was not a tender to our office by day 30. There actually wasn't.
It was a tender by day 30, just not a tender to your office by day 30.
Well, a tender that, going back.
You're not disputing that, are you? That there was a tender here as to the diminished value check?
Well, tender requires actual production, right? And so it gets into, do you tender, if this had been sent to a cruise ship in Alaska, I know that's not the facts, right? But if this had been sent to a cruise ship in Alaska, would that be a tender? The fact that it went to the plaintiff's house here was not a term which was a part of the offer. The offer said you must tender to us, to plaintiff's counsel's office. It wasn't tendered to plaintiff's counsel's office. The fact that a very well-meaning representative testified, well, we're used to dealing with diminished value checks. We typically handle those with the person. We typically engage with them. In this case earlier, we engaged with them. All of that is an explanation for a good faith, and we didn't never subscribe bad faith, but good faith is not a tender when there's a condition there as to where the tenders, to get back to your question, the act of tender can mean different things depending on the course of dealings between the parties, the correspondence, the agreement. There can be a case where tender is in the mail. There's no question there's case law that allows for that under those case-specific circumstances. This unilateral offer did not say you can tender it, that's sending it in the mail with the condition to our office. That is the key distinction between these cases where merely saying, I accept in the mail, for example, bilateral contracts, I accept. That can be a contractual acceptance. I offered to buy your house for $100,000. I send an email, the person sends an email back, I accept. That's a contract, right? The mere email, or it could be sent in the mail, in the snail mail, so to speak. But here, the condition was tender to our office within 30 days. There was...
Counsel, the word tender means something short of delivery and receipt. I mean, it's you try to, and I think there's a case that says to make an effective tender, you have to actually attempt to pay, attempt to give the money, whatever else. And here, there was evidence, not crystal clear, that Geico did generate a physical check through their mailing branch or whatever you want to call it. It looked like they might have probably did mail it, so they actually took some step to make the payment to do what you asked. And it was you or whatever who chose to use the word tender rather than deliver. So under that circumstance, doesn't it appear that there was evidence the trial court could rely on in saying they did make a tender of both the BI and the diminished value checks?
I would respectfully say no, Your Honor, because the condition was the delivery, the place of delivery here was to our office. They never attempted to deliver the diminished value check to plaintiff's counsel's office. I would submit that the bodily injury attempt is not sufficient either because it had a date certain to arrive by day 30. But in order for...
It appeared that they mailed it, and I can't remember exactly, but around April 14 or 15, and the time frame was to April 29 or 30, something like that. So
You're very close, yes.
close enough for this,
Exactly.
right? So, I mean, the evidence indicates that they mailed it a couple of weeks before the deadline. So they actually attempted to pay the sums due within the time frame, and we have no idea where the check went, but if things had gone according to normal, that check at least would have made it to the office, you would expect.
The bodily injury check, if it had been sent, but even if they could prove it had been sent and there had been a postal service problem, they made the decision there to not hand deliver. They made, I think in my opponent's answer brief, they're saying I'm raising a new argument by discussing the mail. I'm not saying they couldn't have mailed the checks. The offer did not require hand delivery. It did not require the Geico check, car to come. That is 100% true. But if you're going to take it upon yourself with a unilateral offer which requires performance to use the mail, this was their system, 500,000 pieces of mail a day. I understand that's a course of business. If you're going to take that risk upon yourself, you better darn sure make sure that it arrives by day 30. How do you do that here? The steps, there was no obstruction here. The step that they took was on day 30, and I don't fault defense counsel personally. This is not in any way. Defense counsel sent a letter to the effect of, please confirm that you have received the checks that have been received. That's on day 30. I don't know the time of the day.
Wasn't there on April 21st, and again, I may be off by a day or two, but around April 21st, wasn't there some correspondence from defense counsel to plaintiff's counsel saying, I understand they've already sent you the checks?
There was. That is true.
And the response that drew, and there was more to that saying, we're still working on the affidavits where it says basically the insureds have no money and no other insurance. And the only response from plaintiff's counsel was, well, what's taking so long on the affidavits? How about instead of that? We've already checked. We'll do this which will satisfy us instead, but nothing about, we haven't gotten the checks yet.
Right, but there's no obligation. There was no.
I agree, I'm not saying it's their obligation, but
A different set of facts. If plaintiff had received the check on April 22nd at their house, and plaintiff's counsel was aware of that, and the letter went to plaintiff's counsel, and plaintiff's counsel sat back, I wouldn't be here today. Because to me, that's not playing right, that's not playing fair. That's an affirmative misrepresentation. I wouldn't be here. But those are not the facts we have. We don't have any misrepresentation. We don't have any obstruction. We don't have any hindrance by plaintiff's counsel here. They didn't respond. With the April 21st, the letter said the checks have been sent, so, there wouldn't have necessarily been any reason to doubt that they hadn't been received. But the day 30 email, if they had had a conversation and if the record showed defense counsel called plaintiff's counsel up and said, have you received the check? And he misrepresented, I wouldn't be here today. Those are not the facts that we have. We have the email sent, and I'm not personally degrading defense counsel here in any way, but she sent an email saying the checks, it's my understanding the checks have been sent. He did not respond on day 30. I don't know if he received the email or paid attention to the email, but even if he did, it is not the offeror's obligation with a unilateral offer to tell the other side affirmatively.
again, if a tender is making the effort, actually doing something to try to send it, when there's evidence that looked like they mailed it or may have mailed it, defense counsel followed up on April 21st to the extent of saying, the checks have already been, I understand they've already been sent to you, not silent. I agree on day 30, sending a letter, not exactly belt and suspenders kind of stuff, but everything indicated that they had made that effort. And again, tender means something less than delivery and receipt. So
It does, but here the tender, and I know I'm just repeating myself, tender was to the office. That was it's a closer call, I would agree, on the bodily injury check from my perspective. But in order for a reversal here, I don't have to show both. I have to be correct as to that one of the two was not complied with here, because there does have to be complete performance. And the diminished value check there was no attempt ever to send it to plaintiff's counsel's office here. That's undisputed. We know where it was sent. It was sent to the plaintiff's own apartment.
I don't mean to use up all your rebuttal time if you want to.
Oh, thank you very much. I will. Just very briefly, just because I don't want to say something new, it's not fair to opposing counsel. My second point has to do with the client consent issue. I'll just rest on and what I said in my papers with that, only very briefly. The issue of client authority, which was raised in an affidavit, which was raised at the hearing, and so I would contend that it is properly preserved. But if this court holds that what happened here was a tender of both of those, there was a lack of client authority because the client represented an affidavit that his understanding was that the funds would be received. And so that is an independent basis if this court concludes that there was an effective tender between the lawyers. I just want to briefly mention that, to be fair. Thank you very much, Your Honors.
May it please the court, Brett Albrecht of Kubicki Draper on behalf of the defendants, Jennifer and Carlos Juarez. The trial court was correct. There is a settlement in this case, and the defense summary judgment should be affirmed. I'd like to just focus on a few main points and, of course, answer any questions the court may have. And the points are these. First, the terms of the offer. Second, the tender of the two checks. Third, the timeline, and then the client authority issue. And in there, I will be addressing the arguments that plaintiff made. First, the terms of the offer are very important. We understand that the demand letter required performance within 30 days. However, what were the material terms?
What about, though, the tender to counsel's office? That didn't happen here.
Your Honor, this demand...
You would agree it didn't happen here?
With the
Tender
diminished
to
value
counsel's
check,
office.
the bodily injury check was properly addressed to the office. However, the diminished value check or property check was sent directly to the plaintiff's home address. So, However, that's a very good question, and I did hear plaintiff's counsel say a number of times that the demand letter says that the checks are to be tendered to the office. The defense would submit that the offer does not actually say that. Those words are not in the demand letter. The demand says, as a pre-suit offer, we have been authorized to settle this claim for the full bodily injury policy limits of $15,000, along with $2,663 for the diminished value claim contingent on there being no, and it goes on, Your Honor, and we do quote it at length. It's several sentences down before you get to any addresses, and the address is connected only directly to providing the insurance disclosures. It says in the middle of the paragraph, and provide updated insurance disclosures pursuant to 627.4137 to our office. That's the only place in the letter it says to our office at the Suite 200 address. And I'd also...
There are several things in that sentence, other than just that last part. It says,
That's
if you
correct,
do this,
Your Honor.
this, and this.
There are, and...
Why are we ignoring the first part of the sentence?
So, well, I was trying not to read the demand letter that we had already quoted in our brief, but I think that also is a good point. Those other items were not mailed to plaintiff's office address, and plaintiff accepted performance of those terms. So that confirms that the actual where, as long as it was to plaintiff's attorney, the actual physical address of the tender was not a material term. And so for instance, the initial providing of the acceptance and proposed release on April 14th, that was mailed to plaintiff's P.O. Box, which is one of the 3 addresses on their demand letter. The insurance disclosure was provided by email twice. The affidavits of my clients, the insureds, were provided also by email.
Got there. The check.
That's correct.
The BI check didn't get there.
That's correct, Your Honor.
So they're not complaining about things they got, they're complaining about what they didn't get.
And I understand that, and I think that's where we come back to what is the meaning of a tender. But before we get to the details of tender, I just want to emphasize there are a lot of details that the demand was silent on. That does not make the demand ambiguous. In the defense position, it just means that those logistical details were a procedural formality, not an essential element. The silence just confirms that the terms plaintiff is now saying negate the settlement were not truly material terms. And the trial court found the actual receipt and delivery to plaintiff's office address were not material terms, and the trial court was correct.
What do you do, and again, this is, we could find this in any number of cases in Williston, probably, on contracts. I'm just going to read to you from Lunas, which is a second DCA case. An acceptance of an offer must be unconditional and identical with the terms of the offer. Do you agree the acceptance was identical with the terms of the offer?
It has to be identical on the material terms. That's
so
why
you would say this was identical with the material terms?
Yes, Your Honor, because the main term at issue is what's going to happen with the checks, and the checks were to be tendered. That term, tender, is very important because, as Judge Edwards has already recognized, the term tender means something short of delivery. This demand letter nowhere used the term receive, pay, delivery, did not use those terms at all, especially not regarding the checks. The checks are the key.
So you can tender something effectively to the wrong address?
Your Honor, there wasn't a wrong address issue here
I'm
at all.
talking about the diminished payment check. It
was sent to plaintiff's home address. It wasn't an incorrect address. It was just missing the apartment number. And if
So
plaintiff...
I just want to make sure I understand the position. So if you are told you need to send the check to a certain place, and you send it to a different place, but as long as you send it somewhere, that's tendering?
Your Honor, that's not what this demand letter said.
No,
If-
no, I'm asking something different. If you
If
send
it-
it to a different address than what's asked for, that wouldn't be
If
tendering.
you send it
Do
to
you-
a-
You agree with me on that?
Yes, Your Honor.
Okay, so how is this different?
This is different because the demand did not specifically say tender to the office address. Also, we have to look at whether, we're not talking about sending this to Alaska. This is not a completely wrong address. It is sending it directly, the diminished value check, directly to the plaintiff's home address, missed the apartment number, and it brings us back to the definition of tender. As we argue in our answer brief, this demand required a tender, so we have to look at, well, what is a tender? A tender means actual production, issuance of the checks. There's no dispute over that. The question is whether that second part is met, a bona fide attempt to timely send or deliver the checks to plaintiffs or plaintiffs' counsel's office. Now, I understand that plaintiff argues that an attempt is insufficient to constitute a tender, but attempt is actually what makes a tender different than payment, receipt, or delivery. And we do cite a number of cases that stand for that position in our brief. The one that says it the most directly is the South Fork Investment Group case. And on page 79 of that decision, it says, to make an effective tender, debtor must actually attempt to pay the sums due. Mere offers are not enough. And that's what we had here. We have actual production of both checks, and although the facts of the attempted mailing for both checks are slightly different, the fact remains that both checks were attempted to be timely delivered. And that timeline is also very important because this was 2 weeks before the demand expired. Geico said on behalf of the defendants, our insureds, we do accept on the same terms. We're working on the affidavits, and we will provide the check under separate cover. So, and I believe that the adjuster said that twice. So twice,
Well, it
2
didn't say
weeks-
we will provide, it says we have provided.
It does say we
past
have
tense.
provided, and indeed, on the 15th, the diminished value check was actually put in the mail, and there's substantial evidence of routine business practice that the bodily injury check also went into the mail on the 16th. Even though that couldn't be conclusively proven, that combination of the check actually being produced, issued, printed, and processed for mailing 2 weeks before this demand expired, that is the attempted delivery or attempted mailing, which we are arguing is sufficient to be a tender. And
Your Geico representatives, when deposed, said they understood what they had to do was get the money in the plaintiff's lawyer's hands.
And the trial court addressed that at the summary judgment hearing, and he correctly noted that that is the legal definition of tender is a matter of law for the court. What a lay witness who's not an attorney's subjective understanding of what that means is not dispositive. And we've cited case law that tender means actual production plus a bona fide attempt to timely deliver. And that's exactly
So
what
all
was
this
done
meeting
here.
of the mind stuff really doesn't matter because there's,
It's a meeting of the minds on the essential terms. Here, the term demanded was a tender, and a tender is exactly what was done
the
here.
only minds probed were the two Geico reps who said in the hand, right?
Well, Your Honor, again, a subjective understanding is not sufficient to change the objective meaning of the terms used
But
in the
again, I'm
demand letter.
saying, meeting of the minds. There's only
They
two
said
minds.
the same thing, Your Honor, and that's all that's required. They don't have to mean the same thing. The meeting of the minds is objectively, did they say the same thing, even if they may have subjectively had some slight differences on exactly what was required to meet the demand. I want to discuss the timeline here. We talked about when the two checks were issued, produced, and printed, and mailed or
What
processed.
do you do with the argument, and you heard it from counsel, there's a definitive deadline. You have the right to get it there any way you think best. You chose mail, and that's your right, but you do so at your own peril by not getting it there by the deadline. What do you do with that argument?
So my answer to that is actually twofold. The first part, you may not want to hear me repeat, but it all still goes back to that term tender. Tender does not mean actually pay, deliver, receive by the deadline. Tender means actual production plus an attempt to timely deliver, and that is what was done. The second part of my answer to that is if actual payment, delivery, receipt was a material term, number one, the demand would have said that. Those words are not in the demand, it only says tender. And number two, surely the plaintiff's lawyer would have answered and told us as defense counsel that they didn't receive the check. And that request was not just made on the last day before the demand expired. It wasn't just made, it was made on day 30, but it was made before that also. Again, 2 weeks before the demand expired, GEICO says, on behalf of the defendants, we accept the checks have been sent under separate cover. Indeed, the evidence shows that they were. 1 week before the demand expires, defense counsel reaches out to plaintiff's counsel by email on April 21st of 2021 and says, we understand that GEICO has already provided the checks. We're still working on the affidavits. Can we have an extension? In response to that, plaintiff's counsel did not say anything about not receiving the checks. Instead, he said, why do you need extension when there's still 7 days left on the demand deadline? There's a phone call the next day where they discuss the affidavits, and plaintiff agrees to modify what was required for the 2 affidavits, but still says nothing about having not received the checks. And that's why, we go to the last day before the demand expired, and the trial court is correct that this case is very analogous to the Lee versus Chmielewski situation, where we're trying to obtain confirmation. Have we done everything you asked to your satisfaction? Is there anything else that you want us to do? It's our understanding you already have the checks. If that's not correct, let us know immediately. And I know that plaintiffs...
Did you ever really ask that question?
Yes, Your Honor. I mean, different words were used, but it says...
Well, I think, and correct me if I'm wrong, I thought defense counsel on the 2 occasions said, in essence, I think GEICO's already sent the checks, or I understand they've already sent the checks.
In the April 21st email, that was the wording. In the April 28th letter...
You ever asked, did you get them?
So that was what she was asking. If you don't have them, let us know immediately. In the April 28th letter sent by email.
That was the deadline day?
Yes, Your Honor. That was the one on the 30th day.
Was that letter sent by fax, email, or mail?
That was sent by email, Your Honor. So here, if it was a material term, they would have used deliver, pay, receive. They used the word tender instead. If it was a material term, surely they would have let the defense know that they hadn't received the checks. The case of Lee versus Chmielewski is, and I'll end with this point, Your Honor, Lee versus Chmielewski is very similar. Plaintiff questioned why the checks were not hand-delivered. It's because they were sent, issued, produced, sent for delivery 2 weeks before the demand deadline. In Chmielewski, it was a shorter deadline. It was only a 14-day demand deadline, and the offer was not accepted at all. Nothing was said about the offer until the last day, after business. The adjuster in that case for the liability insurance company, also GEICO, said, we accept, and then sent someone to hand deliver the check because they didn't accept until the last day. In this case, GEICO issued, produced, sent the checks 2 weeks in advance, and then started following up. I'm not suggesting that plaintiff had to respond. However, because he didn't, that combined with the fact that the offer said tender, not deliver, receive, pay, it must mean the actual receipt by day 30 was not truly a material term. The diminished value check, if plaintiff had actually received it, there would be no question that a settlement exists. So I think that also goes to show that the exact whether it was plaintiff's counsel's office or directly to plaintiff's home address, it was not an essential element. And that's exactly what the trial court found. The trial court found that under that definition of tender, that there was an actual production of the checks and a bona fide attempt to timely deliver it to the plaintiff, whether his attorney or directly to the plaintiff. Very briefly on the client authority issue, we're not saying that issue is not preserved. We're saying as a practical matter, the fact that plaintiff did not argue lack of client authority in their response to defendant's summary judgment motion, it's very telling. This was raised as an afterthought verbally only at the summary judgment hearing. If they had raised it sooner, perhaps this would have been an evidentiary hearing instead. But it wasn't until the summary judgment hearing 3 years after this lawsuit was filed that plaintiff first raised this lack of authority argument. And his only argument is that although he did authorize this offer in these amounts, he wanted the offer to say actual receipt of the checks within 30 days. Plaintiff's subjective intent about the words used in the offer does not negate the client authority that he gave his attorneys to make the offer in the first place. And Your Honor, they did file the lawsuit the day after the demand expired, so it was impossible for this to be corrected, especially before the demand deadline, when they did not tell us they didn't have the check. So for all those reasons and those further discussed in our answer brief, we are asking this court to affirm the final summary judgment for the defendants. Thank you, Your Honor.
Thank you. Rebuttal?
Thank you, Your Honors. The argument that the letter doesn't state the location of tender, I don't think is well taken. It says tenders and then to our office 4 lines later. The only reasonable place to have tendered the funds would have been to plaintiff's counsel's office. And in terms of the diminished value check, immediately after the sentence saying that the diminished value check shall be payable to the plaintiff, we will ensure that the funds are properly distributed and will handle all liens. So the only way that we will ensure that the funds are properly distributed would be if the funds were sent to the person who sent the letter, which was plaintiff's counsel. And so the representative's testimony about, it's one thing to say that the GEICO representative's testimony as to tender is a legal definition, but there's another part of their testimony which does go to this issue. Both of the representatives acknowledged that the location for the funds to be sent was plaintiff's counsel's office. That is a fact, which I think is the only reasonable interpretation of the letter. It was their attempt to perform was not identical. They did not comply with the material terms. As I said, it's a closer call with the bodily injury check where you have sent it or the business records show that there was an attempt to send it to plaintiff's counsel's office. The record is undisputed. They never attempted to send the diminished value check to plaintiff's counsel's office. That was a material term as reflected in the letter. It does have meaning for counsel to have the checks, to satisfy liens, to handle before there's any distribution of funds in a contingency fee case, you need a closing statement with your client. And so those were essential in material terms as to where the diminished value check was supposed to go. The Lee case, I know we addressed it in the briefs and briefly. The most important distinction is that in Lee, there was an attempt to bring the check during the time allowed under the offer. Here, there was never, for the diminished value check, an attempt to send it where the letter specified it was required. And so because there was not complete performance of all material terms, there was not a settlement between the parties within the time given. So we would respectfully ask this court to reverse and remand for further proceedings. If there are no questions, I thank you all for giving us the time today.
Thank you both. Before we call forward our next advocates, if you'd be kind enough to let them pack up, get out of the well of the court.